So here's how to use the TERA report. The TERA is just one step in a continuing process of gathering information. Other processes include discovery and investigation and other methods that are actually referred to in the report. By itself, no document is evidence without foundation testimony. So the TERA is not evidence unless it's accepted by a court into evidence, which is possible under certain circumstances, but basically it won't be allowed in most instances without somebody testifying, I wrote it, it's right, and here's why I wrote it. The best use of TERA is to provide a blueprint for a competent lawyer to draft and drive the narrative of the case, and that means driving the demands for discovery, motions, objections, and cross-examination at trial. TERA stands for Title and Encumbrance Report and Analysis. The analysis is the most important part. And the purpose of it is to understand the origination and reported transfers of your alleged loan. You'll understand later why I call it an alleged loan. The debt is there, but whether it's a loan in the conventional sense is another story. In the TERA, you get facts about the rights to enforce, and that means facts about your opposition and the positions they're taking and the documents they're attempting to use. And you get facts that would support foreclosure defense, such as a break in the chain of title, or a hidden break in the chain of title. When you look at the actual assignments or endorsements and so forth, you find that they're deficient. So how is the TERA different from a title report? Well, first of all, it includes a title report. Second of all, it's an analysis of the encumbrances. So whether it's a lis pendens or a mortgage or a deed of trust or what have you, or an assignment, we look at the document to see whether or not it passes muster and whether it could be connected to an actual transaction in real life. So this goes much further than just saying, well, a mortgage was recorded on October 10th, 2010. TERA also includes an analysis of the signature blocks and the signatures. When somebody says they're signing on behalf of the XYZ Corporation, which is the successor by merger to the ABC Corporation, which is executing as attorney in fact for the 123 Corporation, that requires analysis. And some things that might seem obvious may not be exactly the way you think it is. Sometimes we uncover significant breaks in the chain of title just from the signature block. So we look at everything from the top to the bottom of every page of every document. We're looking not only for things like barcodes and other codes in the right-hand corner, upper right-hand corner, or the bottom of the page, etc., but also to see whether or not there's any evidence that the document has been copied multiple times in an effort to exclude something that is on the original, or in an effort to create the illusion that something is on the original that really isn't, and it's only on the copy. So we're examining from multiple perspectives. Obviously, if we spot anything, it has to go to a forensic document examiner, who we will refer you to. We are not forensic document examiners. And ultimately, we start the process of giving you guidance on strategy for discovery and trial. So use the TERA to support demands for discovery in court. Use it as a checklist for discovery. Use it as a checklist for qualified written request and debt validation letter. Use it as a checklist for your complaint or answer. And use it with expert witness testimony. And I would remind you that the TERA report is not evidence. It can be evidence if it has foundation testimony and if the judge lets it in. So to attorneys who are seeing this, I want you to know that we are your friend. While I've been in practice 41 years and I have lots of litigation experience, obviously, I do not go to court anymore, and I am not looking for clients that want me to go to court. You're at no risk of me poaching a client. So we refer business to you once we know about you without a referral fee. No obligation on your part. We, of course, do accept donations to the Living Lies blog, but that is not a requirement at all. You refer to us without risk of losing your clients. We do the intake. The client pays, not the attorney, and we give you the blueprint for the case if we're hired to do the TERA and the case analysis. Sometimes, depending upon the knowledge of the attorney, the TERA is all that he or she needs. We can do the drafting. We can draft a complaint, an answer, an affirmative defense, a counterclaim, motions, discovery, and we can prepare attorneys for appearances in court. We actually have several that consult with us from time to time when they're about to appear in court, and we help them prepare for their appearance. For homeowners, we are your friend. We will do everything we can within the scope of what we're offering as services to lead you and help you find traction in court and improve your chances of victory or the satisfactory settlement in the form of a modification or other settlement. We can reduce your overall costs. If you do work with us first and then go to the attorney, or have your attorney order things, because in that case the material that we develop will be covered under the attorney work product privilege. So theoretically, if you place the order through him, give him the money, and he pays, then he can decide what, if anything, he wants to disclose or use or whatever. You can do things without an attorney. We guide litigants, and mostly we tell them what not to do, but we also can tell you what to do when you're filing something in court or going to court. And we reduce stress because we're there. We'll give you the blueprint for the case just like a lawyer. And that really lays out the strategy and narrative of the defense for the case. We can do the drafting for you on things like qualified written request, debt validation letter, rescission letter under the Truth in Lending Act, a complaint to your Attorney General's office, a complaint to the Consumer Financial Protection Board, your case narrative, and of course prepare you for court even if you have an attorney, because there are certain things you should do and not do as the client when you go into court.